rise. All persons having matters before this court, draw near and give your attention. The Honorable Francis Rayford presiding. Be seated.
This is Law Journal. The plaintiffs have more evidence than the prosecutors in the criminal trial, and the burden of proof is easier. But even if the shoe fits, will O.J. Simpson walk away from any legal responsibility?
Here's the host of Law Journal, Attorney Christopher Naughton.
Well, why are these being called the trials of the century? Is it media hype, or do they have the right stuff? Certainly, we've seen more compelling evidence before, more compelling witnesses before, better lawyering, better judging. But you know, America likes a good crime story, especially when it involves a famous figure, especially when it's murder, and especially when all the jury can go by is circumstantial evidence. No eyewitnesses, so move over Bruno Hauptmann and the Lindbergh baby case and Buster Keaton and Charles Manson. The O.J. Simpson trials have drawn our attention not once but twice, and now in round two of the civil case there's an avalanche of evidence from the plaintiff's side. We have compelling photographs, and still some bright legal minds believe that he will literally walk away from it all. Tonight on Law Journal, the O.J. Simpson trial, if the shoe fits. And we want to remind you, if you're watching in Philadelphia, Wilmington, Delaware, across New Jersey or the Lehigh Valley, 1-800-426-4625 is our telephone number. I don't know how many phone calls we're actually going to get to tonight because we have a very august panel, and all of these gentlemen are civil trial attorneys, and some are criminal trial attorneys, so you know what that means. Good talkers, good speakers. John Vivian joins us tonight from Vivian Law Offices in Easton, Pennsylvania, a trial practitioner going on about 20 years, and he's made a name for himself in both personal injury work, but also representing employees in employment matters and discrimination cases. John came up with the largest verdict in Pennsylvania for a sexual harassment case going back about 2 years ago. Seated next to him is Stephen Scheller with Scheller, Ludwig, and Beatty in Philadelphia and Westmont, New Jersey. And Steve has also made a name for himself in litigation, particularly in mass tort litigation, dealing with breast implants, tobacco, and he's written many articles for legal publications across the country, particularly on junk science. And seated next to Mr. Scheller is Amos Guren, and Attorney Guren is with Starr, Guren, Davison, and Rubin in Roseland, New Jersey. And Mr. Guren has been practicing upwards of about 20 years now, and also Amos started out as a prosecutor in the U.S. Attorney's Office in Newark, New Jersey. He is a civil trial litigator, and he and his firm have made a name for themselves in many areas of personal and business litigation. Dick Stevens, next to him, is also a civil litigator representing corporations and representing hospitals when it comes to medical malpractice, but also involved with plaintiffs and defense work when it comes to civil litigation. Glen Clark joins us this evening. He too is from the Lehigh Valley, joined us the last time we did a program on O.J. Simpson, goes back about, well over a year. Glenn is a former member of the AG's office in the greater Lehigh Valley, prosecuting criminals, and then of course he has moved over to the other side of the fence now, representing those accused criminally, and a trial attorney for well over 10 years. And seated next to him, another trial attorney, Dennis Ortwine, who's with the personal injury firm of Cohen, Feely, and Ortwine in both Allentown and Easton. And Dennis and his partners are known for their fine personal injury litigation work throughout the Lehigh Valley and beyond. And again, folks, tonight we will be taking your telephone calls. Before we give you that number, we're also running a survey tonight. And again, if you can't get through on the 1-800 number to talk to us here in the studio, here's our question tonight for the survey. You can call in. Do you think that this jury, not what you would do, but do you think that this jury in the O.J. Simpson case will find O.J. Simpson liable for the death of Ron Goldman and the battery of Nicole Simpson? If you believe that, yes, this jury is going to come back with a liability verdict of some sort, even whether it's $1 or several million, 798-4001. I want to remind you, that's the 610 area code, by the way, 798-4001. If you don't believe they'll come back with a liability verdict, 610-798-4002. And if you don't have an opinion, 610-798-4003. Folks, this case, I've got to throw this first to Glen Clark. We had a chance to talk on the phone yesterday. And Glen, let's start with you, because there are a lot of people in this nation, I think you're probably one of them, that's questioning whether we should even be taking the time, whether we should even be making the effort of going through a second trial. Now, I know Americans believe, or they understand now, there's a difference between civil trials, there's a difference between criminal and civil trials, but should O.J. Simpson be tried a second time? Is there something wrong with our system that says you get a second crack or a second bite of the apple?
Well, I don't think there's anything wrong with our system, because our laws in Pennsylvania and in California permit this kind of thing to occur. But I think we do have to think about, the rigors of a criminal prosecution and all the forces of the government brought to bear against an individual who then gets acquitted, and then you have to turn around now and go through the rigors of a civil prosecution, which, to some degree seems to be somewhat unfair, notwithstanding the high items that are at stake. So for me, the law permits it, but I think maybe sometimes we ought to take a look at that. Maybe one bite at the apple ought to be enough.
Who do you think had the upper hand this time, Amos? Do you think that plaintiffs had the upper hand this time, or defense after the first go-round?
I think the plaintiffs did because of a number of factors, which goes in part to the question you asked a moment ago, which is you have a situation where the plaintiffs have the ability to use all the evidence that's been organized and obtained by the government in an extensive investigation with unlimited resources, unlimited funds. Witnesses who've come back for the civil case help the plaintiff. Some, I take it, for less than might have a professional witness might cost, or for a person who's hired independently. And there's been some criticism of that. I frankly think that
criticism in what way?
In the fact that there's sort of a cooperation between the government's role and the plaintiff, because they're on the same side. They lost in the prosecution. Now they're pursuing the civil aspects. I for one think that when the government has done an investigation that the plaintiff can take advantage of, and that often happens in all kinds of incidents like airplane disasters and bombings and the like. Whenever you have that, you should take advantage of it and use it to your best advantage.
So it's okay, Dick Stevens, occasionally you go on the defense side. Anything not kosher about that?
I happen to think that the ability to use the government's information is good. I mean, we have that all the time. You have a drunk driver who has killed a group of people. He may or may not have been acquitted, but you're going to use the same evidence. You're going to use the same state policeman. You're going to use the same group that you had before. And I don't see anything wrong with that. I think that, and from what Glenn said, the idea of two trials doesn't strike me as terrible, because it's a whole different trial. It's a different burden of proof. Clearly in this case, and I think this is something we have to remember, as the show indicates, the shoe evidence is in this case, which was not in the criminal case.
Let's take a look at, we have a graphic here of some of the differences between the civil and criminal cases. It comes to evidence differences. First off, we have the Bruno Magli shoe pictures, and we have well over 30. We've been talking about 30, but there are one or two others showing him with Bruno Magli shoes. Simpson purchased, there was testimony about Simpson purchasing a black sweatsuit, and also that sweatsuit, I think it was made of velour, I'm not really sure. Those fibers matched at the crime scene. Again, the prosecution didn't have this going back over a year ago. Caitlin changed his testimony a little bit. We call it Cato's new testimony. The lie detector test, which, I still can't believe that that Fujisaki allowed that to come in, but that was not present when we went the first go-round. Paula Barbieri's Dear John call, the day of the murders. I don't know why they didn't have that for the criminal trial. That was one additional item the plaintiffs brought in. Another item is that the Bronco chase material admitted into evidence in this case. The passport, the gun, the disguise, prosecution decided not to use it in the criminal case. Admission to Detective Lang in the Bronco chase by O.J. that he, quote, he was the only one that deserved to get hurt. So this jury heard that. Another issue is Nicole's phone call to a women's crisis center 4 days before the murder. It was a woman named Nicole, married to a very famous individual in West Los Angeles, and she feared for her life 4 days prior to the murder. And then finally, admitting into evidence the quote-unquote suicide note with the O.J. smiley face on it. And last but not least, the plaintiffs had O.J. Simpson on the stand this time. So it seems like this almost should be a no-brainer in one sense, because we have the burden of proof becoming lighter and easier, and we have this avalanche of evidence. And yet we're going to poll you folks tonight too, and I've polled you before you even came here. There are a number of legal minds that say he's still going to walk away from this.
Well, I think you have to remember one thing. This case, from the defense standpoint, rises or falls on O.J. Simpson. If they believe O.J. Simpson And he sat there and said, I didn't do it. That's all they need. If they believe him, and I'm not sure that I can understand how they can believe him based when you put all the other evidence, but that's all they need.
Right, well, there's a couple of other major differences. The jury comes from a county which is predominantly white and certainly would not, I think, be as favorable to O.J. Simpson in the county where he was tried in the criminal case. In addition, the jury is only required in a civil case in California to agree 9 out of 12. In Pennsylvania, it's 10 out of 12. There are a lot of nuances. The problem that you also need to understand is the judge in the case, I think, was very favorable to the plaintiff, to put it mildly. He allowed evidence in that I think never should have been permitted in. And more importantly, he denied Simpson the right to produce evidence that even in the criminal case he was permitted to produce. So you begin.
So why do we have this undercurrent? Like, I've had very few attorneys, civil litigators, like we have here tonight, and one criminal trial attorney. Very few of them will go on record, if you will, and say, "Oh, yeah, 99% certainty that O.J. is going to be found liable." John Vivian, I've heard some people say, "Okay, this is a civil trial. We have a preponderance of the evidence. That's what the black letter law is, but in reality, this jury may try this more or less as beyond a reasonable doubt." What do you think of that?
I don't think the jury will. And not only that, but we've gotten some of the clippings that Dick brought with him and some research we've gotten off the internet. There are actually two standards. There's not only preponderance of the evidence, but many of the questions, as I understand it, are going to require clear and convincing evidence in between that standard.
I wasn't aware of that. Okay.
And that's a very difficult.
Here are the interrogatories
that the judge actually has.
You might want to
Okay, thank you.
That's for the punitive damage aspects. You have to have clear and convincing evidence under California.
Okay, so clear and convincing, which, if we were to use percentages, and I get this is a shortcut of sorts, but preponderance would be something like 51%, clear and convincing would be something like 75%, and beyond a reasonable doubt would be somewhere around 90% or so.
Nobody ever uses those
I understand.
figures, but and I'm not sure I agree with John that the jury makes that fine a distinction. I think this jury is going to decide this case on whether they believe the mass of evidence or whether they believe O.J. Simpson, because it's basically I didn't do it. This is cooked up evidence. Everybody's against me. There are so many liars, which is one of the things that the plaintiffs really spelled out for that jury. Can everybody here be lying? And they said, they talk about these pictures and of the shoes. One of them was made 8 months and published 8 months before anybody got killed. And they never bothered to refute that evidence.
I think that the one which appeared in the National Enquirer, they did refute that one scientifically. They did bring a witness for that. But the 30 that were brought in by the individual, the private photographer on the Buffalo Bills football field, I don't think they've even touched that.
And they really didn't
More
touch
important and
too
more
much.
troubling. More important and more troubling, I think I agree with you that number one, it's going to depend upon whether the jury believes O.J. Simpson. The advantage in the civil case, as we all know, and unlike the prosecution, we have the right in a civil case, the plaintiff's attorney, to call, for instance, Mr. Stevens' client if he's doing defense work, put him on the stand, and cross-examine him. The question is whether or not the jury believed O.J. at that time. The other thing is that Henry Lee's testimony was taken in this case by videotape. As you know, Henry Lee is one of the outstanding criminalists in America, and more troubling to me is that there appears to be another footprint with shoes that definitely were not Bruno Malley's shoes. The other troubling aspect is that they talked about those shoes, and primarily what the defendant has done in this case is they're talking about the timeline. You still have the same troublesome timeline of 10:35 to 10:40, and to be able to get home by 10:55 to be on a plane. And Henry Lee's testimony, if believed by the jury, could be the wild card. I, however, think that in this type of a case, as a plaintiff, I would like this type of a case because I think the burden of proof is somewhat less, especially on some of these questions that require what we describe in our law as a featherweight, slightly tilting the scales. Those cases are better for circumstantial evidence, I think, than criminal cases.
Chris,
just a minute. Let's take Glen Clark, and then we'll go to Steve Scheller. Go ahead, Glenn.
Chris, I think the thing that one of the things that concerns me is that when you take into consideration all of the evidence that was presented in the criminal case, and after the trial, this country's in an uproar over that verdict, and people virtually across this land have an opinion one way or the other as to his culpability. And then you get a second bite of the apple in that context. And all I'm suggesting to you is that perhaps, I mean, I don't even know how you get a fair and impartial jury. I mean, you got to be...
Not for this trial.
You know, not for this trial. You know, there are many other trials you can, but in this trial, how do you do that? So this jury, when they sat there and took their oaths, for the most part, I submit to you, already had an opinion one way or the other on his guilt or innocence, actually, whether or not he's liable in this context, and that is a problem for the defense. Notwithstanding all the other, whether you believe O.J. or you don't believe O.J., it's a problem.
Steve Scheller?
Well, there's another big problem. I really think this is going to be a possibly reversible decision, no matter what happens, because of the errors made by the trial judge. So we may be back for trial number 3.
I don't think we'll see O.J. 3. For some reason, I think the money's running out in Santa Monica. Plaintiffs, defense attorneys.
Well, I'm wondering also why the plaintiff's attorney, where he's going to. This is normally you handle these cases on a contingent fee. One of the major concerns, I would think, from a plaintiff's attorney's vantage point, is what assets does O.J. Simpson have that...
But Steve, this is not really about money. I mean, the defense wants to lead us to believe this is about money, and I know that Baker brought this in. Amos, this isn't about money. This is about accountability and responsibility.
It's not, and I think that's why it's really going to be tried essentially at a criminal trial burden of proof level, in spite of the fact that it's a so-called wrongful death action. It is a very rare opportunity that a plaintiff's attorney in a civil action for wrongful death is able to say to a jury, the defendant intentionally, maliciously, wantonly did something wrong. You might be able to say it in a case like Steve has, cases where you have manufacturers of breast implants or tobacco, whatever, but you cannot say that in the average automobile accident, the average fall accident, medical malpractice action. Those do not involve intentional acts. Those are accidents. That's why they're called accidents. And here, it's going to be tried as an intentional act.
But there's a very good reason that we all know that they are not made to be intentional malicious acts in the civil case, because then you don't have...
I don't get coverage.
...any insurance coverage.
But beyond
because the insurance companies do not cover if you tried to run down... If I try to run down John Vivian, I don't get a dime from my company. His lawyer, you, doesn't get a dime. If I did it negligently, I get a dime.
The thing is, I think we have an agreement here. This is really not about money. Dennis...
I think that's right. I agree with that.
It's not about money for anybody, but the plaintiff's lawyer...
Who disagrees with that? Glenn
I
disagrees?
disagree with that.
You really think it's about money?
I disagree. Oh, yeah. I think that you got to be serious about the judicial system, and to go through the months of agony that the Goldman family, for example, has gone through. And now it's not going to get vindicated no matter what the jury decides.
Glenn, you don't think that they were just so outraged by this decision that they figured, we're going to find some forum, some court in this land, and we're going to find this guy, if not guilty, because obviously he's not going to be found guilty ever again, we're going to hold him accountable. Some court, some jury, some judge, some forum is going to find this guy responsible.
He's never going to get found guilty. He's been acquitted.
Well, that's what I'm saying.
He's never going to get that.
But the thing, don't you think it's more about not revenge so much, but again, this feeling of satisfaction, avenging the death of his son?
Now you've hit on a nice word, avenging.
Not money.
However, it may be avenging, but I'm submitting to you
that may not even be the right word.
Right. Well,
although it worked well in your scenario.
Yeah.
The fact that maybe that's what you believe it is.
Right. I don't believe it. I believe it's about money as well. I don't think it's simply a matter of going to court and going through all of this problem without money. I find it a little bit disingenuous for the lawyers and all the pundits to say that it's not about money. It surely is about money.
Well, except where is he going to get the money? If the criminal lawyers left him with any, which I doubt, where is this money that you're talking about going to be coming from?
Well, that's a separate question.
I think what the people want here, the plaintiffs really want justification and vindication. I don't think... There's no amount of money can bring their child back to go through this kind of a harassment for 2 years. I don't know. I don't view their motivations in this case simply as money.
And I don't see their justification for it, because to get a victory in a county which is favorable to them, with a favorable judge, with the situation is a Pyrrhic victory. I mean, I don't know that they can ever really get back what they lost, and that can't happen.
That's right.
And I think it's unfortunate that our legal system has to be tied up in this kind of situation. And what else comes out of this, if you really wanted to look at this case on the cold facts in terms of what the verdict potential of the case could be, and you look at the situation where courts have made awards. Let's take an example of a punitive damage award. The U.S. Supreme Court recently ruled, well, you can't have punitive damages more than 3, 4, or 5 times what the actual damages are. Now, California appears to be a state where you actually have to have actual damages.
Compensatory damages.
And the actual damages here in terms of monetary loss are not that great, frankly, unless you conclude that pain and suffering, which is significant, is worth a lot of money. But you know, in New York, it's similar. There's the attorneys in New York always run around, and the defense attorneys, I have to say, do it. They kiddingly, unfortunately, say it's cheaper to kill somebody than to just maim them, because if you kill a child, they have no loss potential, and punitive damages, you're not going to get anything multipliers on it.
Let me throw this to Dennis Ortwine, because Dennis, I know that your firm, as other firms here, handle wrongful death cases. When you go into a wrongful death case and you're trying to assess what a case is worth, and I think Steve said it, often if someone is left injured for life, the damages are going to be a lot higher than if you do have a wrongful death matter. You're involved in this case. Let's say you're plaintiff's attorney. What kind of dollar figures, if any, do you put on this?
Well, the damages that you can get in Pennsylvania, first of all, have to deal with the actual losses that Goldman or Mr. Goldman would have suffered. How much would he have earned during the course of his lifetime had he lived? There are damages that are not also so concrete. In other words, there are the pain and suffering damages that were spoken of, and again, it was 1 second's worth of pain and suffering worth $10 million. I agree. I think that it's going to take a lot of persuading on the part of the jury to bring back substantial numbers. You have to understand that jury in California could come back and find out that, or find that O.J. Simpson was negligent. They could also come back and say that the family was not entitled to any money as a result of his negligence. So it's a matter of...
not much money.
Or not much money. There's going to be money involved because you have to come back with a verdict. But I know the one thing that they raised was that Ron Goldman would have had trouble getting a credit card because of his history.
Right. Interesting tactic used by Baker.
In California, the test is not negligence. This jury is not being asked a negligence question as they would be in a wrongful death case here. And in that sense, it differs from the Pennsylvania law. But the first jury question they have to ask is whether by a preponderance of the evidence, they have shown that he willfully and maliciously killed Ronald Goldman. That's what it says.
Yes. It's not even wrong. It's not even wrongful death against Nicole.
No, it isn't. They did not bring one.
You asked earlier about whether this is about money or vindication. I think it is vindication. You got to recognize that the Goldmans and the Simpsons, the Brown family rather, will have the ability to hound Mr. Simpson for 10 years with a judgment, if they get a judgment. If it's not dischargeable in bankruptcy, and I think the punitive aspects for the most part will not be, and then can renew that judgment for another 10 years. That is tremendous ammunition for Fred Goldman, who has shown himself to be one of the most resilient people in a trying time that I've ever seen and that the public has seen. As far as money is concerned, all of these people are going to make tremendous money from book rights, from movie rights, from interviews, including the Goldmans and everyone else.
You know, it's an interesting tactic. If you listen to, or if you watched, or if you heard on the news some of the closing arguments from defense and from the plaintiffs, both sides were arguing common sense. They were both saying, come on, think about it, people. This is, it just doesn't wash. It doesn't smell right. Just use your logic. Just think. Common sense will tell you ... Which I think it's kind of peculiar because in some regards, if you think for a moment that O.J. Simpson, if all of, if the DNA and the blood evidence and the hat and the glove, if you use common sense, unless you buy that there's a conspiracy theory, common sense is going to tell you that there's an avalanche of evidence. Where do we get defense coming off saying use common sense, Glen Clark?
I don't know. No, we don't know where the defense comes off using common sense. But I can tell you what, this case is fraught with problems. In the graphic that you put up there, some of the evidence that came out, the Bruno Mali shoes and all of that. First of all, a lot of that evidence, usually experts. First of all, that's expert testimony, and that's the lowest grade of evidence that's offered, and it creates a lot of problems. I mean, in terms of the Bruno Mali shoes and the blood evidence and all the other items that they brought in to try to bolster up the case that fell flat on the criminal side. some of those things are questionable, highly questionable. Letting in the the lie detector, whatever that was let in.
Reversible error is
there
what
was
that
no
is.
foundation for any of that
Could be.
stuff. I don't know what that was about, but those things are going to create a major problem. So this case is going to, the jury's going to reach a conclusion, and I think we're going to have more litigation.
Well, there's another damage that we really didn't talk about, and another risk that was taken by the defendant. In the civil trial, it was not taken in the criminal trial, and that is that they attacked the character of Nicole Simpson, and they did it through OJ. That's a big risk. That's a double-edged sword. I know Mr. Stevens, when he does defense work, that's a risk you generally don't take. That can backfire. That could feed the fuel for the punitives, or it could work in OJ's favor if they find that the jury in this situation could find that he's downplaying her. And the other thing we haven't really talked about is, I'm not positive, but I believe from the closing arguments I've read that California happens to be a soulless state. In other words, they can award damages for the grief and the loss, at least with respect to the Goldman claim. That's something we don't have available in Pennsylvania, and that could be whatever the jury wants it to be. It's almost like another aspect of pain and suffering. So they can talk about, what do you pay a father for losing his son's companionship? So that's a form of compensatory damage allowed in California, not allowed here.
Tort reform down.
Yes.
Well, that's allowed in New Jersey. New Jersey, you're allowed to bring...
I agree with you. We need that in Pennsylvania.
In New Jersey, you're allowed to bring in an economist or other experts who can talk about loss of companionship and family services and put dollar values on those things in terms of everything from taking a loved one to a doctor or helping them with a checkbook or helping them with family responsibilities.
And I certainly agree with
can
my
do some
colleagues,
of that.
except in medical malpractice cases.
Yeah, I bet you
The rest of it,
we can do
ought
that
to allow
also.
that.
Under our Death Act, our Wrongful Death Act, we have pecuniary value of those services. But California will allow award of damages merely for the grief of losing the child, which we don't have here. That's a very dangerous
also-
damage.
Do you have that in Jersey, though?
No, not
not
simply
in
for
gr-
grief.
Oh,
not
okay.
for simple,
Right.
which clients, of course, have a hard time understanding. But you mentioned common sense earlier, and I think the trump card, so to speak, that the defense has here, that the defense has here, and that the defense had in the criminal case, is police misconduct. The public is suspicious of law enforcement, is suspicious of the police, and often rightfully so. And as a result, you have an attitude, and unfortunately, Mr. Simpson is getting the benefit of that, and I don't think the public in general thinks he ought to, but there's an attitude that the police, if they do wrong, have to suffer the consequences, and the case has to suffer the consequences.
Well, that's more
and
true
there's
of
a serious
criminal
issue
case,
there.
though, where
Yeah, not so much
not
here.
so much of a civil case. Plus, the judge did a pretty good job of cutting that aspect out of the case, and that may be part of the reversible error.
He did
Because
a good job.
Yeah, I believe it is. The judge said right up in the front of the case, he said, well, you're not going to be able to put in proof that somebody else did it. And I don't know in any case that you can't do that. I'm also troubled by the polygraph evidence, and I believe that the plaintiffs are going to prevail in the case, but I believe, as you do, Steve, that there is some definite reversible error that occurred here. And I don't know that the plaintiff had to put those things in to prevail, to be honest with you.
Well, I tell you, I'd go out on a limb here and say that if there is a verdict in favor of the plaintiffs, I don't see the appellate courts in California reversing it.
the appellate...
You can talk about philosophy all you want, but they're going to say, I think, that was discretionary with the trial judge and that he did not overreact. Matter of fact, I think that, differing from you fellas, I think the trial judge in this case did a very good job. I think he kept control of the courtroom, which I think is absolutely essential for a
I hear
trial
Glen Clark
judge.
rumbling. Glenn or Dennis are rumbling.
I agree with Glenn on this issue.
And John agrees too. Yeah, we're going to poll our panel here, and then we've got a survey question which we're going to get to in a second. But let's go on record. John, Vivian, you said you feel that this jury is going to come down with a liable verdict.
I believe they will. I also believe he's going to get a new trial if it ever goes on appeal.
Steve Scheller, what do you think is going to happen here?
I believe they'll come down with a verdict for the plaintiffs. I think the amount of the verdict might very well be high, but will be subject to reduction, reverse, never be collected. But more importantly, I do agree. I think we get to a point in some litigation where appellate courts are affected by what happens outside in the world. And they may take the position that even though all of this reversible error occurred, and had this been the ordinary trial and we followed our ordinary view of the law regarding justice, they would probably reverse it, but not in this case. I think you might be right. I think the same thing is now happening, for example, with the tobacco industry. I think we've kind of had it up to here with their lies. And I think their days are over.
Are numbered as well.
Yes.
Hopefully we're going to get to that at the end of February. Amos Guren, what do you think this jury's going to do?
I think this jury is going to find the defendant liable. I think the issue of damages is another issue. I think there is not a lot of proof in support of the traditional compensatory damages, and I'm not sure what the charge by Judge Fujisaki was on that issue, but I think that's going to limit it. And punitives, as I understand it in California, have to have some reasonableness in relationship to the net worth of the defendant, and we're not sure what his net worth is or what's touchable in his net worth. That is a real problem in all the states, including in New Jersey, where we're limited to 5 times the compensatory damages, not to exceed $350,000 in New Jersey on punitive damages. And of course, that's why the plaintiff's bar has fought that and has lost, of course, at this point. But that's why, in the rare case where punitive damages are needed, they should not be restricted.
Dick Stevens, what do you think this jury's going to do?
Well, at the time of the criminal trial verdict, I was trying a case in Northampton County, and the court let us all go and watch the verdict, and I was probably the only voice in the room who said it would be a not guilty verdict. And so I was right on that prediction, so I now have at least a 50% chance. So whatever I say, I certainly can't hurt my record more than 50-50. I think the jury has an opportunity here to do what juries often do, which is to compromise. And here they can find, with that jury verdict slip that I've just given you a copy of, they can find finding a battery on the preponderance of the evidence, but find not a malice on the clear and compelling part of it, which gets rid of the punitive damages as I understand it, and they can do a compromise verdict. And I think that's a very real possibility here. But if they don't do that, I believe that the verdict in this case, differing from the other one, will be a verdict of, in effect, what it will be is a verdict of guilty, even though they don't use that language.
Glen Clark.
Chris, you never know what a jury's going to do.
I know that.
It is extremely difficult to come up with an idea of what they might do. But if you look at all of the factors and the evidence, the pressure that this jury is going to be under, the sentiment across this land that O.J. Simpson's a murderer, which all of them, I've heard that, by the way. So with all of that, I think there probably will be a plaintiff's verdict, but I think it's fraught with problems in terms of being able to hold that in.
Yep.
And I don't think this baby's over yet.
And Dennis, what do you think?
Well, first of all, I was utterly amazed at the verdict that came down in the criminal trial. I just couldn't believe that 12 people could find O.J. Simpson innocent of the crime that he was alleged to have committed.
Or at least that the prosecution didn't carry their burden.
Exactly. As far as the civil case is concerned, I guess we'll make it unanimous. I believe that they're going to find that O.J. Simpson was responsible for the death of Ronald Goldman, and they're going to come back with damages. As far as how much they're going to come back with, it's anybody's guess. Whether or not it will make any difference, it certainly isn't going to bring back Ron Goldman, and it certainly isn't going to make O.J. Simpson's life any more miserable than it is right now.
Let's also put that survey question up for you folks. Again, during tonight's program, although I know you're not going to have an easy time getting through to us in the studio tonight, you can dial these numbers. Do you think this jury, not you, do you think this jury will find O.J. Simpson liable for the death of Ron Goldman and battery of Nicole Simpson? If yes, dial 610-798-4001. If no, dial 798-4002. And if you don't know, or if you don't have an opinion, dial 610-798-4003. And we want to remind you folks, we're not going to be taking a commercial break tonight, so we want to let you know if you'd like a VHS copy of tonight's program or any program we do here at Law Journal, you'd just like to write us and tell us what you think or some suggestions for some topics. You can write to us at Law Journal, P.O. Box 484, White House Station, New Jersey, or call us at 908-534-1600, or in Pennsylvania at 610-797-4530. And because we're not not taking a break tonight, I just want to remind you folks again, we do have a 1-800 number. We're going to get to your phone calls in just a minute. And again, just so if you've just tuned into the program, we're here tonight with civil litigators and a criminal trial litigator as well. John Vivian from Easton, Pennsylvania is with us this evening. And again, a civil litigator going on about 20 years now in both employment and plaintiffs matters and product liability, personal injury, and the like. Stephen Scheller and Scheller, Ludwig, and Beatty, known for their work in breast implant and tobacco litigation, coming up now in civil courts of law. Also a firm known for its workers' comp legal practice as well. Amos Guren hails from Starr, Guren, Davison, and Rubin in Roseland, New Jersey, a civil litigator, the firm representing personal and business civil litigation interests. And Amos at one time also prosecuted criminals with the U.S. Attorney's Office in Newark. Dick Stevens with Stevens and Johnson, a long-standing Lehigh Valley practice, and Dick and his partners and associates are civil litigators, sometimes for defense and for plaintiffs as well. Glen Clark, a former prosecutor as well with the AG's office in the Lehigh Valley, and now defending criminals in criminal trial matters. And also seated next to him, Dennis Ortwine, a civil trial attorney with Cohen, Feely, and Ortwine. Let's get to your phone calls, folks. I know you have a couple of questions of my panel tonight. So up first is Maria. Good evening, Maria from Philadelphia. What's on your mind?
Yes, I have been following O.J. Simpson's trial from the very beginning, and I more or less put myself like one of the jurors. And I was listening to the whole case, and I could not possibly find one reasonable doubt that he was not guilty, because I was wondering, how does his blood goes, there are drops on her property, then blood of the victims on his property.
Well, this is the question that comes up again. Even if it's a conspiracy, and let's say the LAPD did something wrong, let's say they did something illegal, immoral, and unethical, the question still has got to be asked, how does his blood end up on the gate? How does it end up in his Bronco? How does Nicole's blood end up in his Bronco? How does it end up back at his house? How does Ron's blood end up on him? How does his hairs end up on Ron Goldman? I mean, it would have to be, again, Glenn and Dick, and I know we were talking about some of the factors, and John, we were all talking about the fact that maybe some things are wrong with this case. Maybe the LAPD tried to pad this. But even with things such as contaminated blood, if it's contaminated, it's not going to show up as O.J. Simpson. It's going to show up as something that's contaminated. There still seems to be too great an avalanche, even in the face of a police conspiracy, to say that this man wasn't at the scene, didn't commit these crimes.
How do we decide, though, that there was this great police conspiracy? I mean, it is certainly known that if the two of us are police officers, we might cover up for each other. But the whole police force, all of the experts, that's
well, there's questions about the socks, Dick. There are questions about the socks, and I think that they are good questions.
There are questions.
And maybe what happened here was that the initial evidence showed that O.J. Simpson was the guy, and somebody maybe in-house said, we're going to make certain that that is the case.
Yeah.
And we're going to position these socks, and in the end, in the final analysis, they killed their case.
Yeah, but they killed the case in the criminal courts. But what you say, of course, is that O.J. Simpson did it, and then the police tried to make a better case out of it, but you still come with the fundamental question, did O.J. Simpson do it? And you start off with that as your premise. Well, if you say that, it takes away from your argument, I suggest.
I think, Chris, you made a very good point. It was all too overwhelming. There was too many things that just sort of fit into the puzzle to make it possible that the jury would not doubt this evidence by reasonable doubt, and juries use common sense. And then you add to that the fact that the prosecuting attorneys very much overtried the case. They did a terrible job, and for them to get all this publicity, write books, and teach in law school, I wouldn't want to be a student of those two, because frankly they don't know how to try a case. If I worked for me in my prosecutor's office, first of all, I want to know why the prosecutor moved the case to that county, which they did as I understood it. Two, I want to know why he let them run loose like that. I mean, these were like two kids with a cookie jar. They didn't know what they were doing.
But you see the difference. I mean, in every case, civil and criminal, credibility is what is the linchpin of a verdict and a decision, and why a decision is made a certain way. And you always have, in a criminal case, the focus is the police. The focus is on the police who organized the evidence, who culled the evidence, who maybe lied about their motives for even coming onto O.J. Simpson's property. So once you have a situation where they lied about one or two serious issues, then the jury can make a fair determination that they're not believable. And of course, ultimately, the biggest lie was Furman, who was caught in a terrible lie, and the prosecutor had embraced him. In a civil case, the focus, unlike the criminal case, is no longer the police. It's O.J. Simpson. He's lied about the photographs. He lied about the shoes. He lied about the critical items. Where are the clothes? He lied about the kinds of things that people would know in their everyday lives.
And so we get back to what Dick Stevens said at the top of the program, Amos, which is it's going to come down to, since this is more or less like a reasonable doubt standard and burden of proof here, it's going to come down to, does the jury believe O.J. Simpson?
Absolutely.
And so, and I have not yet an attorney yet who has said, boy, he didn't really hang him. Did he not hang himself early on when he said, I never hit Nicole, I never raged? Go ahead.
But Chris, but what you've got to remember is, what did he hang himself on? I mean, you know, the fact of the matter that I don't think anybody in America believes he didn't have some marital problems with Nicole, and maybe had a sort, what you call it, a push, a shove, or whatever. There was a problem there. That's a given. But to translate that and say, well, because he abused her, that now he murdered her sometime later, you got to link that up. And it wasn't linked. Then you've got the chain of custody. Remember, the Bronco was left unattended in somebody's lot for an extended period of time. You got a chain of custody problem there. I mean, you just can't, I mean, it's there, but it's not there clearly. There are too many little question marks that can come up. So I can see how our jury I would agree that there's a lot of evidence that most people would get convicted on. There's no question about that, I think. But I think there's also area and room to find reasonable doubt. Unlike the caller said before, she couldn't find one reasonable doubt. I disagree with that. There are some things you might have doubt about. I think perhaps a reasonable person might have come to grips with it and put it in context or perspective. But there are things that you could have had doubts about.
And if this jury follows what the court is going to tell it on the preponderance of the evidence test, it's just whether the scale tips a little bit in favor of the plaintiff. It doesn't have to do a reasonable doubt.
But that's not going to happen here, though.
Well, I don't think it is either, in the sense I think the jury is not going to be going by that as much. They're going to make a decision on their own. But it's O.J. Simpson. Now, O.J. Simpson cut his finger, and he told a half dozen stories. Now, I cut my finger the other night because there was ice on the roof and my wife is away. So I had to knock it down, and the piece of ice hit me and cut my finger. Now, I know how that happened. It didn't happen 4 or 5 different ways that I don't remember how it happened. I know exactly how it happened, just because I let my wife go away and I had to get the snow off my own roof. My daughter's in college and she didn't come home to help me.
But of course he referred to that cut as something innocuous. I could have been wrestling with my son or something like that. He didn't really remember where he got that cut.
You do remember where you get cuts. I mean,
well, you don't know.
Well,
yeah, if you get 3 or 4 or 5 stitches, maybe.
I didn't take any stitches. Come on. But you remember those things. That's why the plaintiffs say common sense.
Right. We have to remember that in our justice system, the issue is not perfect justice. There can't be such a thing as perfect justice, and we don't expect it. We have a system that sets forth that a person is still not guilty of a crime if, by a reasonable doubt, the jury believes that, even though they may be guilty. That's not the question. There's lots of people that are guilty of crimes that never get arrested. There are many people who are charged with crimes who don't get convicted or are found guilty of a lesser degree of crime. The civil system is somewhat different, but it's still the plaintiff's burden of proof, even though they may have a valid case. We know, for example, that there are many times when we have a case come into our office and we say to ourselves, I know that medical device caused that injury. But the burden of proof is not shifted to the manufacturer to disprove that. We still have to go through hoops to prove it, and we've been doing that now with the tobacco industry for several years, and we have finally got the world started to be convinced that, hey, these guys are bad guys, and times are changing. A lot has to do with the public opinion in our justice system, and therefore we have to understand justice is not perfect. It's not meant to be. That's our system, and it can't be perfect. And we're never going to make it perfect, and we should not insist on perfection. We can criticize. I can say the 2 district attorneys that prosecuted the case didn't do a very effective job, Johnny Cochran is a very fine defense lawyer, as he is. I can say that the plaintiffs in this case, in filing their case in a county where they're going to have a predominantly white jury that is absolutely convinced that something is wrong here that needs to be redressed, was a choice. But that still is our justice system, and that had more to do with this case, where it is, who the judge is, and how it was presented, and what the press says. And that's,
of course, if the quote-unquote predominantly white jury in Santa Monica comes down with a liability verdict, then what's most of America going to say? Well, see, you know, Black America would have said said not guilty. White America saying guilty, and again we get back to along strict racial lines, which is kind of frightening.
Right, it isn't resolved.
Very frightening.
I never thought of this as a racial division. I think it's a police credibility issue. There is a racial aspect to it too. I'm not being that naive, but I think you have to realize that O.J. Simpson has a persona, always has had a persona in this country. He was liked before this happened by blacks and whites, young and old, sports fans and Hertz Auto fans and movie fans from the comedy movies he made. He was loved by everyone, and most people were aghast at the idea that O.J. Simpson could do this, and it had absolutely nothing to do with race. He was, as people like Michael Jordan, for example, in this country, have been accepted by blacks and whites, young and old, all across the country, and by advertisers and the public. That persona is probably his best shot in this case.
And in this case, it really is. It's his charisma and it's his believability that may carry the day. But it is still a sad day that, in many people's opinions, that the first trial was jury nullification, and now we get back. Now we get to this trial, and it's for revenge. And if a white jury finds him liable, again, I think we're back to square one. I think it's
what would have happened if the first case had been a guilty verdict? Then would we hear that the prosecutors were wonderful, that the defense lawyers made a lot of mistakes?
I think that they would say at that point in time that race wasn't an issue. Just as if this jury comes back with a not liable verdict, I think this country will say, well, gee, maybe it wasn't so much a racial issue.
I think you're right. If this jury does that, then they're going to say it wasn't a racial issue. I think that's true.
But
that would be the wrong reason to have a verdict, however, just as it might have been a wrong reason if that was the reason the first verdict.
Hey, I want to remind my viewers, just a moment, John, just for a second, we'll pick up on you, and we've got some interesting calls we want to get in. A survey question. We've got a few more minutes left in tonight's program. If you can't get through on the phone lines, you can dial in and put your vote in for this survey, tonight's call-in survey. Do you think this jury, not what you would do, but do you think that this jury in California, Santa Monica, will find O.J. Simpson liable for the death of Ron Goldman and the battery of Nicole Simpson? If yes, dial 610-798-4001. If no, 610-798-4002. If you don't have an opinion, 610-798-4003. We'll be giving you those results towards the end of this program. Again, it's this jury we're talking about.
By the way, when we talk about this jury has a much better advantage than any of us sitting here.
Oh, of course.
Because they have heard all of the evidence.
Well, just our first phone caller tonight says, I've been following this for a long time, and I think that...
But she hasn't
seen
it.
Unless she was watching, even if she was watching every bit of videotape from the first criminal trial, we haven't seen any from the civil trial yet.
But it depends.
She can't make up her mind.
It depends on what the jury believes of the particular witness. A witness can get up in the stand and say, "That's the defendant. He's the one who hit me," or they can say, "That's the witness. That's the defendant. That's the one who hit me." And the jury, the press gives the words the same emphasis, but the way it comes across is totally different, and the jury may believe the first witness and not the second witness, or vice versa.
We have a call from a Chris. I'm sorry, Dick, to cut you off. We have a Chris from Englewood, New Jersey. Interesting question. Chris writes for his high school newspaper. Go ahead, Chris.
Hi. My question is, if this jury should find him not liable of this crime, and O.J. Simpson says, "I did it," and stands up and says it, how will the law
Chris, Chris, let me just ask you a question. Is anything that O.J. Simpson's done since he's become a persona would indicate that might happen?
Yes.
How, when, and where?
When he tells the judge and the jury that he killed them, how will the law treated it as such?
Okay, well,
he would be committed to the nearest but that's not going to happen. Believe me, Chris, you have an interesting point of speculation of what if, but I, for one, would not bet the house on that particular happening.
You know, there are some real inconsistencies in our justice system that trouble me, and we're civil and criminal lawyers here. I personally have a very difficult time understanding how we're spending all this time on the O.J. Simpson trial. A man who was apparently may have been enraged at his wife and comes upon a scene where she's with this younger man and had a knife in his pocket, and he may have killed the two of them in a vicious assault. Or the DuPont situation where the man had schizophrenia. We've arrested him. DuPont trying him. O.J.'s been arrested. The tobacco industry kills 400,000 people every year, addicts them, and we stand back and they can give contributions. They go to church,
as
and
you said,
is mine.
both with breast implants and tobacco industry, and that's such a large problem. And of course, there are people saying that you have
so large that we don't want to.
No, and I think you're right. Their day of reckoning is coming soon, but it seems to be more voluntary. Ron and Nicole didn't pick up a cigarette and say, "I'm going to end my life here." Pick up asked to be knifed at that point in time.
Well, we now know it wasn't so voluntary.
Well, that's also true.
I think the answer is that more people read the National Enquirer than Time, and I think more people watch soap operas than this show. But I think you have all of the elements of great American drama. You have a hero in the sense of O.J. Simpson. You have a beautiful woman. You have the mysterious third man. You have a terrible crime. And you have massive publicity today that carries this into everybody's home every night, and you can't get away from it.
Willie, you're
good
calling
or bad,
from,
that's the way it is.
That is the way it is. Willie from Philadelphia, you've got a comment here, don't you? Willie from Philadelphia. Do we have Willie from Philadelphia?
Yeah, can you hear me?
Yeah, go ahead.
I just wanted to say that I think it's a lot of loopholes surrounding his case, because on any given time, I mean, it's hard to find someone that's not familiar with what have been said, they have heard concerning his case with the evidence and all that. And I think he's going to be found guilty.
You think he's going to be found liable in this case?
He's already found guilty, believe me. I'm telling you now from a standpoint. And everybody that's been involved with it, they seem to when they lead the case, they all go off and make money. So you don't really know who to believe or whether they're being fair.
So you think, Willie, it really is about money?
Just
and
about
you think
money. No if and all about it. I guarantee you, if I ran someone over and I had a lot of money, you're going to come after me and get some money, get paid. If I didn't have anything, it wouldn't even, that'll be the end of it.
Okay.
Well, Willie, let me just say that one of the jurors, a female bank worker, said when she was interviewed, said, quote, Simpson was probably not guilty. And, quote, I didn't think there was enough evidence to prove him guilty. Now, there's a juror who at least starts out with an idea in mind that she has to be convinced. So if I was the defense, I would be very happy with that jury. I don't know why John Vivian certainly wouldn't have let that jury on if they said, we like the doctor.
No,
I believe the doctor didn't do anything wrong.
Good point.
In medical malpractice.
But they have been out of peremptory challenges, too.
He may have been out of peremptory challenges, obviously, as Chris points out. And, number two, and more important, the problem is the defense needs 4 jurors like that in this case.
Right, exactly.
Well, that's true.
Right.
Exactly what they need.
But there weren't any...
Go ahead, Glenn.
Plus, jurors, I've never been convinced that what jurors tell us in the voir dire is 100% accurate. You know what I mean? They tell you pretty much what they think you want to hear, and if they want to serve, they'll tell the court what the court wants to hear.
And this is the jury they want to serve on.
Hey,
Dennis, what is going now that the jury has got this case? Now that I think they've been charged by this point in time. I think summation is over and done with. What's going to go on? Just describe what's going to go on in that jury room this week. I don't think this is going to be a 4-hour jury deliberation. What's going to go on in that room this week?
Well, first of all, they have the jury slip that Dick Stevens, I think, handed you, and they're going to have to go through there and answer the questions in order. And the first question is, do they believe that O.J. Simpson was responsible, and I think he said acted in a willful, wanton, and reckless manner, or whatever that might have been.
Right.
Then they go on to the next question, and the next question, and each of them lead to the bottom line, which is the amount of damages that will be awarded. In between there, and since we have done through our office a lot of jury analysis where we have seen the jurors, I think that they're going to be giving their own basic opinions from life experiences as to why they think maybe he was or wasn't responsible for this act. There's a lot of soul searching that goes on. Just to get back to the basic, and I think that John Vivian said this, I frankly cannot see how they picked 12 individuals who are fair and impartial. I agree. I think that these people had made up their mind.
Well, especially with this kind of case.
Yes.
Amos, what's going through their minds this week? What's the foreman going to do? What do you think the tenor is going to be when this jury gets together in there to deliver?
Well, I think what most juries do, first of all, you don't automatically have a four-lady or four-man. It's usually the first person, but if you have a strong member of the jury, they can, and at least in New Jersey, I don't know about in California, they can elect one of their others to be the foreperson of the jury. You're going to have leaders and followers, as you do in all walks of life, and I think that's what's going to happen in jury.
It's going to get pretty contentious in there,
I think it's going to get contentious, but there's going to be some people who will lead the group and will try to poll the group. And I think what's going to happen initially is kind of a polling and a straw vote of responsibility or lack thereof.
What we heard is that both summations were so eloquent, and Baker came back very strong, I heard, on Monday, and Petroselli's, of course, drew tears. I think this is one of those cases where, you know, there are two distinct roads, and I would think, Dick Stevens, that people have made up their mind. Maybe they've made them up for a long time, and it's going to be really tough to change somebody's mind at this juncture, don't you think?
Well, I think so, but I think one of the things you have to look for is how fast this jury comes back. If this jury comes back very quickly, you're going to know it's there's no liability. Because to answer all of these 8 questions and get to the question of damages, it's going to take a long time. So if it's a fast verdict, I think you can predict that it will be a verdict in favor of O.J. Simpson. A longer verdict doesn't necessarily give us any clue. Although if it goes terribly long, then you might think of a hung jury.
We only have about a minute or so. We're going to get to the survey in just a moment, but I want to thank the law firms. We're here tonight for several reasons, bringing their experience and their opinions with them, and also for the many firms that help us underwrite this program, to do this type of programming. John Vivian tonight from the city of Easton, again representing plaintiffs in employee matters and in personal injury matters. Stephen Scheller from the law firm of Scheller, Ludwig & Beatty in Philadelphia and Westmont, representing plaintiffs in personal injury matters. And Amos Guren with Starr, Guren, Davison, and Rubin in Roseland, personal and business civil litigation firm, Roseland, New Jersey, and New York City. Dick Stevens joined us tonight, and he is a civil litigator for plaintiffs and defense in Hamilton, on Hamilton Mall in Allentown for many years now. Glen Clark, trial attorney, criminal trial attorney, representing those criminally accused, and also Dennis Ortwine from Cohen, Feely, and Ortwine joined us tonight, the personal injury lawyers in Allentown and Easton, Pennsylvania. Folks, here is the VHS tape. That's right. If you have any questions or comments, or you'd like a VHS tape of this show or any show we do, 908-534-1600. Here are the results. Of course, this was the survey tonight. Do you think this jury will find O.J. Simpson liable for the death of Ron Goldman and the battery of Nicole Simpson? And here are the results, okay? If you can read through the bleed through there. 71% said yes, they think this jury will come back with a liable verdict. 25% no, and 4% had no opinion. Gentlemen, they are sweeping me out of the studio. We could spend another hour on this, but I want to thank all of you for joining me tonight. What was a very, very quick hour, and we'll be waiting and watching, and probably be reporting on it ourselves over the next few weeks. What do you think, Amos? 3 weeks, 4 weeks before they come up with a verdict here?
I think it'll be at least another year of commentary at a minimum. Books, articles, and movies.
Keep us going for a while. Again, I want to thank all of you for watching us tonight. Next week, we'll be talking about sexual harassment and sexual discrimination. I'm attorney Christopher Naughton. We'll see you live next Tuesday night. Good night now.